So, chapter 12, landlords and tenants. This chapter is all going to be about renting and the landlords and tenants' rights, duties, obligations, lease contracts, leasehold estates, all kinds of stuff like that. So, in this chapter, we're going to learn about the four types of leasehold estates, describe standard lease provisions, including various forms of eviction. What is eviction? And the effects of the Truth in Renting Act, as well as the Americans with Disabilities Act. We can discuss differences between various types of leases, identify functions of the property manager. And let's start off with what is a lease. It's good to know, I guess, if we're going to be talking about a chapter on leases, to know what a lease is. So, what is a lease? A lease is an intangible or incorporeal asset. And the person who has a lease does not own real estate. They're just renting. So they don't have real estate. So it's personal property because they don't own the real estate. So a lease is an intangible personal asset. The owner, the lessor, intentionally transfers most or all of their rights of the possession to the tenants for a limited period of time, as that's defined in a lease. And a lease also sets forth all the terms of the contract, the amount that's to be paid for the right to use the property, and defines the rights and obligations of each of the parties. Every lease has a demising clause that transfers the property by lease and describes what exactly the landlord is renting to the tenant, and that the tenant is to take possession and when. The lease is both a contract and a conveyance in that regard, because the tenant is getting the property conveyed to them, but it's also a contract that gives them the rights to occupy someone else's property, and it says what they can actually use. You know, like the landlord may rent you the apartment, but you don't have access to the garage. That's where he keeps all of his tools and his car and stuff like that. His belongings. Maybe you get access to half the basement, perhaps. He's got the other half. A lease would stipulate all of those things in it. So let's do the highlights here.
Got it.
All right.
Almost done.
Sure.
And I got it as well.
Okie dokie. So remember the statute of frauds. We've seen it in several chapters already. It requires something to be in writing, but all contracts for the sale of real estate have to be in writing, but leases do not. That is when an agent's not being used or involved, because we always have to put our contracts in writing. But if there's a contract between a landlord and a tenant, no agent involved, they are only required to be in writing if they're 3 years or of length or longer. And and leases can be recorded if they're 2 or more years. You know, even though they're not required to be in writing, it's extremely risky to rely on verbal contracts, oral agreements. You know, how do you prove all the terms that you spoke about or even remember them, you know, later on? So real estate agents, we have to follow contract law, but we also follow real estate licensing law, and that says that all contracts that we prepare must be in writing. All right, estates and land. We learned about them in chapter 6, I believe. An estate and land describes the amount and kind of interest that one has in real property. And back in chapter 6, we learned about the 3 types of ownership estates. Those freehold estates, or is what they're called. And in this chapter, we're going to learn about the 4 types of leasehold estates. So an estate describes the amount and kind of interest that one has in real property. So the 4 types of leasehold estates. Leasehold is less than freehold. You're not free to hold it forever or a lifetime. Freehold is the category of ownership. Leasehold is less than that. You're not free to hold it forever or a lifetime. So it is not ownership. An owner, this is where an owner intentionally transfers some of their rights and interests in the real estate they own to a tenant for a limited period of time as defined in the lease. So a lease is considered personal property. That's, once again, an intangible or incorporeal asset. So the 4 types of leasehold estates are estate for years, periodic estate from period to period, a tenancy at will, and a tenancy at sufferance. All right. So rent is due at specific intervals per the lease. If not stated in the lease, New Jersey law actually says that rent is due in the arrears after the end of the lease term. You know, like at the end of the month, the opposite of an advance at the beginning of the month. Like most leases specify, you know, rent is due on the 1st, but if the landlord fails to put that in the lease, New Jersey law says the rent is actually due at the end of the month after you occupied it for the entire term. So it's very important for us to make sure we put that in the lease when the rent is due. Anyone who terminates a lease early, well, a lease is a contract. They would be in breach of that contract. A holdover tenant is one who did not vacate the premises after their lease term rights had expired and they didn't renew with a new lease or extend it. So a landlord can either choose to accept that holdover tenant and keep them there and collect the rents from them, or they could evict them because they didn't sign a new lease contract. So what is eviction? Eviction is the legal process of removing a tenant through the court systems. A landlord cannot lock out a tenant or turn off their services or physically remove them. The tenant does have rights. Eviction is the process of revoking those rights that have been created and granted to them through the lease. Because that lease expired, so did their rights. But a landlord still cannot be the one that revokes those rights. You got to go to the court and have a judge revoke them. And that's what eviction is. Whether it's because a tenant violated the rights and the lease terms that granted them the rights to occupy the premises, or because their leasehold rights had expired, but you still can't just kick them out. You gotta get the judge to do that. So let's just highlight and write the number 4 there. 4 leasehold estates, and those are the 4 types of leasehold estates. So once again, an estate for years is a lease for a definite period of time. It's for a fixed term. You know when it starts, you know when it ends. An estate for years does not need to be for a period of years, though. An estate for years can be for a week, 3 weeks, a month, 6 months, a year, 2 years. Its distinguishing characteristic is that you know when it starts, you know when it begins, and you know when it ends. That's estate for years. A periodic estate is a lease that has a stated term. However, that term would automatically renew. Instead of having an expiration date in the lease, it actually has a renewal date. And the lease would renew for the same amount of time that the original lease was written for similar succeeding periods of time, until the tenant gives the landlord notice to quit, letting them know that they don't want to renew. But they need to give sufficient time for that notice. If it's week to week, 1 week's notice, month to month, 1 month's notice. If it's a period of years that the leasehold estate's for, then 3 months' notice the tenant has to give to the landlord that they're not going to renew it. Otherwise, it automatically renews. Then we have a tenancy or estate at will. This is for an undefined, indefinite period of time. It does not have a stated ending date in it. It's just the tenant can lease there at the landlord's will until the landlord tells them you got to go. And then they got to give them 3 months notice. This type of estate is usually used when maybe a landlord been notified their property's getting taken by eminent domain. They're just not sure exactly when that is. So in the meantime, they still need to be paying their rent, right? They need to pay their mortgage on their property. They need to pay their property taxes. So they could get a tenant in there to pay rent to continue paying those important bills until the state notifies them they're going to actually take over the property. And at that point, they can notify the tenant, and they'll get at least 3 months' notice. And then a tenancy at sufferance is without the landlord's consent. When their lease term expired, they didn't move out, and they're not paying rent. Every day they remain, they cause the landlord to, thus the tenancy at sufferance. So let's highlight and write those notes down for the the 4 different types of lease terms and their distinguishing characteristics. Okay, so let's do the notes on the distinguishing characteristics of the lease term estate. You know, estate for years is for a fixed term, has an end date. Estate from period to period, a periodic estate, automatically renews, has a renewal date in it from period to period. An estate at will is for an indefinite period of time. It's undefined. And an estate at sufferance is without the landlord's consent. Let me know when you got them.
I got it.
Done.
All right. Then you can highlight estate for years, the notes, as I read them here. Estate for years. Once again, don't let the name fool you. It does not have to be for a period of years. Its distinguishing characteristic is it has a start date and an end date in it. So for a fixed term, could be a week, it could be a week long, 3 months, 6 months, a year, 2 years. Its distinguishing characteristic is you know when it starts and you know when it ends. No notice to quit is required to terminate this type of lease because it has an expiration date in it. So you don't need to give a landlord notice. You just don't renew the lease. All right. You know, when everybody's got that.
Okay, got it.
I have it as well.
All righty. Jyoti, you get a chance to get that? Hello.
Yeah, I got it. Got
Okay.
it. Yeah.
All right. Periodic estate, once again, from period to period. Its distinguishing characteristic is that this type of leasehold estate automatically renews for similar succeeding periods of time until the tenant gives the landlord notice to quit. That they're not going to be renewing. But that notice, how much time needs to be given? Well, it depends on the length of the lease term. You know, week to week, 1 week's notice, month to month, 1 month's notice, period of years, 3 months' notice is required to terminate this type of leasehold estate. All righty. So with a periodic estate, when a tenant gives their notice to quit, that they're moving out, and then if they don't, they could be held liable for double the rent for each month that they've held over. Because the landlord may have arranged already for someone else to get in there, you know? And now their landlord's going to would be in violation of that new tenant's lease. So they're going to have to put that other tenant up somewhere, pay for it maybe, because they didn't vacate. So that's why they're allowed to do that. So let's highlight periodic estate. I want you to cross out the word indefinite, even though it makes sense. I don't want you associating the word indefinite with periodic estate so that you could get it correct, the question correct on exams. Because they got questions on exams about which type of leasehold estate is for an indefinite period of time, and that would be a tenancy at will. Now, it does make sense where they put it here, you know, what they mean by it, because it's indefinite in the sense that it automatically continues to renew over and over again. But there is a definite length for that lease. And then it just renews again. And a holdover tenancy is one where the tenant did not vacate the premises after the end of their lease term had expired.
Done.
All right. So, estate or tenancy at will, I like those notes. It's a lease term for an indefinite period of time. The Estate or tenancy at will, once again, is for a definite period of time, indefinite period, because it's not specified when a lease term ends. You could stay there at the landlord's will or the tenant's will for that matter. Either party has to give 3 months notice to terminate. Termination occurs automatically on the death of either party. And both parties need to agree to the indefinite term with that 3-month notice agreement. And once again, it's often used when a landlord has been notified by the state that they're going to have their property taken by eminent domain, but they're not exactly sure when. This way, a tenant landlord can still lease out the premises and collect rent so that they can pay their taxes and their mortgage, and still have that tenant there. And then they just give 3 months notice when the state notifies them that they're going to terminate their or when they're going to need the property by. And then lastly, we have the estate or tenancy at sufferance. This is not squatters' rights because the tenant at one point had a lawful, valid lease. The lease had expired. The tenant did not renew the lease, but they didn't move out, and they're not paying rent. So every day they remain, they cause the landlord to suffer. Thus, the tenancy at sufferance. Okay, so it's important to write here because the book did not put it in there. They're also not paying rent. Because you could have a holdover tenant, and that's not a tenancy at sufferance. It's a holdover tenant who's not paying rent. That's a tenancy at sufferance. You see, I think I'm getting a call from one of our students here. Let me give them a call back. Maybe they're having trouble getting in. So give me 1 second here while you guys take those notes. Okay, so let's see. Tenancy at sufferance. All right, we got that?
Yeah.
Now, so let's do a recap. A demise is a transfer of property by lease. Leasehold estate is where a tenant's rights to occupy someone else's land are considered personal property, which is an intangible asset. Holdover tenant is one whose rights to occupy real estate expired, but they did not vacate at the end of the lease term. And the landlord has the option of either evicting them or just accepting them as a month-to-month tenant collecting their rents. And once again, there's 4 types of leasehold estates. We have an estate for years, periodic estate, tenancy at will, and tenancy at sufferance. The distinguishing characteristics is an estate for years has a start date and an end date. You know when it begins, you know when it ends. No notice to quit needs to be given to the tenant at the end of the term because the lease expires. Just don't renew it. Periodic estate does have it is for a fixed term as well. However, that term automatically renews unless the tenant gives notice to quit that they're not going to renew it.
Okay.
Then we have the tenancy at will, which is for a fixed, which is for an undefinite, undefined period of time. It's for an undefined period of time. Both parties have to agree to this, and the either party will give 3-month notice to quit. And then we have a tenancy at sufferance. This is a tenant who once had a valid lease. That leasehold had expired. They did not renew the lease or move out. So every day, and they're not paying rent. So every day they remain, they cause the landlord to suffer. Okay. So here's some of the standard provisions put in leases. Parties got to have capacity to the contract, got to have competent parties like any contract. A demising clause that says the landlord's to let and the lessee is to take possession of the premises. And you have to have a description of the premises, what exactly is being rented and what exactly is being excluded from the tenant's use. The term must be clearly stated, the duration, or whether it's at will. That estate. How and when the rent is to be paid should be specified, because if you don't specify it in the lease that its rent is due at the first of the month, when is the payment due? In the arrears at the end of the term. The opposite of an advance. And lease must be in writing if it's a term more than 3 years. It can be recorded if it's more than 2. Doesn't matter the length. If we're involved, though, it needs to be in writing. And we have to have signatures. All the parties, of course, need to sign the lease. All right. Here's the thing about window guard notifications. If you go to page 235 and highlight this section. Guys, I got to take a break really quick. I just got to run in the bathroom real quick, okay? And then we'll get started here again. So just find this and do that highlight. I'll be right back. Okay, so we have the window guards. There's no paragraph anywhere here in the book that talks about window guards, but you need to know about them. So I pointed you to put a highlighted box around section 36 of the actual lease that's in the book that talks about window guards. It explains what window guards are. But I put together a slide for that as well. So if you take a look at this slide, you may want to take a picture of it. I'll give you a little bit more of an explanation. The part that you need to know for exams is in the box here at the top. That says, window guards prevent the window from opening wide enough for a child to fall out. It applies to buildings with 2 or less rental units. Window guards must be installed by the landlord if a child or children of the age of 10 years of age or younger will be living there or regularly present there. If the tenant gives the landlord a written request to install the window guards. Homeowners associations, the HOAs, they're responsible for installing window guards in hallways and common areas if it's a condo. And they're only required on first floor units if the windowsill is at least 6 feet above the ground, 6 feet above grade. Okay. Now, in buildings with 3 or more units, you don't need to know this part for exam, but it could be helpful to have this knowledge. Buildings with 3 or more units, landlords are required to install window guards unless the tenant indicates that they do not want them. And the landlord has to check with the tenant every year before February 15th. They need to get the tenant to reject them every year. They must have the tenant fill out a form that they don't want them. And then installed window guards must be inspected twice a year by the landlord, once between March 1st and May 1st, and again between September 1st and December 1st, and keep a log about the results of the inspections of those window guards. If you have window AC units, air conditioning units, installed, you have to use tamper-resistant one-way screws so that people can't mess with them to loosen them up or take them out without a special tool. To bolt that air conditioning unit securely into the window frame without leaving any open space greater than 4.5 inches where a child can squeeze through and fall out, possibly. And then the landlords are allowed to charge tenants up to $20 for each window guard installed. Okay, but the part that you need to know for exams is just up top. When do window guards need to be installed? Only on first floor units when the windowsill is at least 6 feet above grade. And there are children 10 years of age or younger that are going to be living there or regularly present there. And the tenant requests that they be installed.
So Victor, as you said, the building need at least 2 units. So if this is a single family home, then we don't need a window guard.
Correct.
Okay.
Get a screenshot of that if you have not yet, because there's no notes anywhere in the book about window guards, unfortunately. And you do need to know about window guards.
I have a question, teacher. Since this slide mentioned kids, um I have a friend that wanted to like I was with him when he was doing the when he was looking for a house for rent, right? And they were asking him, "Oh, do you have kids? Do you have pets?" And he was like, "No, I don't have kids. I don't have a dog. Why?" Oh, okay. But like, isn't that also like discriminating like people with kids still?
Well, he's just asking if you have kids. He didn't deny you, right? He didn't deny anybody because they had kids. If he denied somebody a rental because they have kids, that would be discrimination. Just asking if somebody has kids is not.
Ah, okay. Okay, because he made it sound like if you know if he had a kid, he wouldn't be able to rent there, kind of thing.
Ah, well, that would be discrimination. They made it sound that way, yep. And if you ask if they have a criminal history, that's not allowed. That's considered discrimination now in New Jersey. But not asking if they got kids.
Ah, okay, got it. Okay.
All right, so these are what window guards look like, just to give you an idea. Window guard is this metal frame that goes in. You can see it from the outside of the building here, from the inside of the building here. Or if it's one of those swing out windows, it's just an L bracket that prevents the window from, opening more than 4.5 inches. And then you also have the stoppers here so that the rest of the window can't move up more above the window guard. So here's some typical provisions of any lease. You got the use of the premises needs to be specified, and if it's not specified in the lease, then a property can be used for any legal purpose. The term of the lease, what the start and end date or renewal date will be, or if it's at will. New Jersey requirements, agency relationship disclosures, just like in sales contracts. We give the CIS form to renters as well as we do to the buyers, right? It's everybody gets the CIS form, landlords and buyers and renters. And recall what the CIS is, Consumer Information Statement. What does it do? It informs people of the different types of business relationships we could be in. So that needs to be given to tenants as well. Hmm. Oh, dang it. So if you recall the CIS form from the earlier chapters, remember, it just explains the different types of agency relationships, buyer's agent, seller's agent, disclosure, dual agent, designated agent, and transaction broker. Got to open it up from my computer. It's missing a page, but you guys know what it is. We've gone over it before in earlier chapters. All right, so it needs to be given to anybody for residential property, actually residential or commercial in New Jersey, but no, actually it's residential property only and for leases less than 125 days. We need to give them the CIS form before we talk about their motivations or reasons to move. And the opinion 26 notice needs to be the cover page of any contract prepared by licensees. It advises people that they have the right to hire a lawyer. Remember, you don't need a lawyer in real estate transactions, but you better not tell nobody that. You got to inform them they have a right to hire a lawyer. So we also need, if the property was built prior to 1978, we got to give them that federal lead paint disclosure statement, right? Right. Let me see. We also need to give them the pamphlet about lead and a 10-day opportunity to conduct a lead hazard assessment or inspection or turn down that inspection, waive their inspection right. But we also have New Jersey's lead safe law now. New Jersey's lead safe law requires an inspection. Federal law just requires the owner to disclose any knowledge that they may or may not have on about the property, any lead on the property. But the New Jersey lead safe law requires an inspection and requires the property to be certified lead free. All right, so these are the rules on that. And security deposits. Let's talk a little bit about security deposits. The maximum security deposit you're allowed to collect by law is 1.5 times the monthly rental figure. Okay, what is security? It's a guarantee of rent. It's a guarantee that the rent will be paid and that to cover any expenses for damages that a tenant may do. It must be placed in a special interest-bearing escrow account, bank account, used only for keeping security deposits. So landlord cannot put their tenant's security deposit in their own personal bank account. They need to put it in a bank account, use an interest-bearing bank account, and then they can't keep the interest. They need to pay that interest that's earned on that security deposit money to the tenant at the end of the year. And they could give them a credit towards the rent on that anniversary date of their lease, or they could give them a check for the couple pennies that their money may have earned. Now, if the landlord does not do that, the penalty could be double the entire security deposit that they would need to pay the tenant. Yeah, hey, it's their money. Those couple cents of interest that they're earning, they need to pay it to them. So the tenant must be notified where that money is being held, and the tenant must get their interest earned paid to them on the anniversary of their lease. So the penalty for the landlord could be that they could be required to pay double the entire security deposit. Now, the maximum security deposit allowed by law is 1.5 times the monthly rental figure for residential real estate. Commercial real estate, there is no maximum security by law. The landlord can charge as much as they could get away with collecting from the tenant. It is not uncommon to have 3 months rent as security deposit in commercial real estate. 3 months or even 6. Depending the length of the lease term. Now, or the agreement, depending on the agreement there. So pet security cannot be charged. Well, as long as it does not exceed the 1.5 times monthly rental figure. So if you're already charging 1.5 times monthly rental figure as security, you cannot charge any additional security, call it pet security or whatever you want. You can't charge any additional security beyond the 1.5 times monthly rental figure. But if you're only charging 1 month's rent, you could charge pet security an additional half month. But I would just call it security. I would not come up with other names and call it pet security, because now that's what if it's a service animal? You know, just call it security. If somebody wants to charge additional security, instead of doing that, because that's illegal, charge additional rent for the pet. You could do that. Or a one-time fee that's non-refundable for the pet for any damages that they may do. But you can't charge additional fees if it is a service animal, remember. So security deposits have to be returned within 30 days of the lease termination if there's no damages. Penalty for violating that is double the security deposit. Any deductions the landlord makes from the security deposit for damages must be on an itemized report provided to the tenant within 30 days. And if the property is sold, the landlord has to turn over security deposit by law to the new owner, and then the new owner will be responsible for returning it to the tenants when they move out if there are no damages. So there you go. Do those highlights. It's about what we just went over on the previous slide. Let me know when you get that. You guys got that?
Yes, I do.
One more minute. Okay, got it.
Okay. So late payments can be charged to tenants, but you got to check your local rent control laws if your municipality has rent control. Not all municipalities have rent control laws, but those that do, you got to check what the rules are about. Can late payments be charged? How much can be charged, and when they can be charged, and to who? Some tenants must be given a 5-day grace period free from late fees and penalties. Those people would be those relying on Social Security benefits, old age railroad retirement pensions, or any government or quasi-governmental pension or payment. Because if the government is late paying the tenant, the landlord can't hold the tenant responsible and charge late fees because the money they relied on was sent late to the tenant. They have to be given a 5-day grace period free from any late fees or penalties. But beyond 5 days, they can start charging. So always check the local rent control laws, if your town has them, to see how much you can charge in late fees and penalties, or if you could charge them and when and to who. Okay. So let's do those highlights.
So Victor, late payment is void for the senior people also?
For everybody. You gotta pay your rent on time. Hey, you're occupying someone else's property. You gotta pay them for that. It's not a charity. All right. Possession of the leased premises. Tenants cannot take possession until the date specified on the lease. And you as a licensee should never give a tenant access or the keys, even only just to put a few of their belongings in there before that lease term begins. Because if you do that, well, then they took possession legally because they got some of their stuff in there already. Now you're risking your license if you do this. You're also risking the landlord having to be stuck with a squatter or somebody who ends up not paying the rent, and but yet they need to get evicted out of there because you allowed them to put some of their belongings in. You just created a whole nightmare scenario for that. So don't ever give a tenant keys or access or allow them to put any of their stuff in the premises even that they signed a lease on until the fruition date of the lease comes about, where their lease term's supposed to begin, and after the city inspections have been done. So let's actually even write that in there, you know. Let's see. So you got to get the city inspections done there too, to make sure anytime that there's a tenant turnover. All right, so can a landlord enter an apartment without the permission of the tenant? We went over this video actually in chapter 4. So this is the one where the landlords, one of their workers, used their pass key to get into the apartment, and then he started rifling through the guy's fiance's underwear drawer, doing unmentionables to her unmentionables. And nobody was home though. But so was anybody sexually harassed or anything? No, because nobody would have known if the guy didn't have the camera there. But no, the landlord or their workers cannot enter somebody's apartment without the permission. Remember, what is a lease? A lease is where a landlord intentionally conveys all of their rights and possession of the premises to a tenant for a limited period of time as defined in that lease. And so they can't just use their key to enter the door. Only in cases of emergency, like gas leaks or flooding or some other emergency. Otherwise, they can be charged with criminal trespass. All right. And we got that from that Truth in Renting booklet. Truth in Renting booklet defines all of the rights that the tenants have. This is available in, it's not printed anymore. It's just available in PDF and gets updated regularly. And this booklet is landlords must give it to tenants in buildings with 3 or more rental units, explain to them what the rights and duties are of the landlord and the tenant, and a bunch of useful resources there for tenants, maybe legal help, if they need help paying some utility bills, if they fall on hard times. There's all kinds of if you got questions with issues with the landlords on certain things, then you can get your answers from the Truth in Renting booklet often. So, yeah. Let me share that with you, the Truth in Renting booklet in the chat window. You can have to go to DCA's website to grab it, and it's available in English and Spanish. All right. Legal principles of a lease. Improvements. Can a tenant just do improvements without the landlord's permission? No. You can't even paint your apartment without getting your landlord's permission first, right? So doing any improvements, no, you're going to need to get their permission to do that. So trade fixtures, those are fixtures used for commercial properties for conducting a business. So they're considered personal property, and a tenant can remove those before the lease expires. Otherwise, they can become the property of the landlord. And those trade fixtures can become fixtures, and fixtures are part of the real estate. Trade fixtures are personal property attached to the real estate. But they can become part of the real estate if the tenant does not remove them before the lease expires. Some examples of trade fixtures would be a barber's chair, gas station pumps, the sinks in a beauty salon, shelving in a supermarket, the range and hood and stoves in a restaurant, etc., etc., etc. So, on page 240, next to improvements, let's write those notes there. So you write next to above improvements, write trade fixtures, tangible personal property / chattel, chattel or chattels.
When you get a chance, can you go back one slide after this?
Sure. Let's get these notes first, and I'll go back to the one slide. Everybody get this?
Got it.
All right. I went back to the one slide. This is the slide you wanted?
Yes, got it already. Thank you.
You're welcome. All right. So, So maintenance of the premises, leases carry an implied warranty of habitability, that the premises, that there are no conditions that would make the premises dangerous or cause a threat to the health or safety of its occupants. So leases carry an implied warranty of habitability, that the premises are habitable and do not have any conditions that could pose a threat to the health or safety of the occupants. The tenant must return the premises in the same condition as received. The landlord's responsible for repairs unless specified otherwise in the lease. Tenants are responsible, of course, for any damages they do. And the DCA, the Department of Community Affairs, inspects buildings with 3 or more units, not counting the unit that the owner lives in, at least once every 5 years. Now, this inspection is called the green card inspection. It's actually it's just a state inspection, but the industry lingo, we refer to it as a green card inspection. So we may say, hey, does the owner have the green card? We're not talking about immigration's green card, that kind of green card. We call it a green card inspection because usually when at least in the past, when the people pass the inspection, the state would send a pass certificate that you'd put in the hallway, and the card was had that water ink on there, the security feature, and it showed that and the card was green in color. So we called it the green card inspection. That's the state inspection that's required at least once every 5 years. Now, if rent is withheld by a tenant to force the landlord to make necessary repairs that they're not doing, they're allowed to do that. But if the rent is withheld, the tenant needs to keep those funds in an escrow account so that after the landlord does the repairs, that they pay all that back rent that they've been withholding. You don't just resume paying rent from the day forward where they made the repairs. The tenant was withholding the rent while they were still living there, so they're going to need to pay all that back rent that they've been withholding, trying to force the landlord to do the repairs. And a lot of people misconstrue the law here. They think they know the law, that I could withhold the rent and then start paying it once you make the repairs. Yes, that's true. But the little important part that you miss, that a lot of people miss, is that you got to pay all that back rent that you've been withholding too. You don't just get to keep that. So let's do some highlights here about the green card inspection. I just put a bracket here for the repairs because the New Jersey does recognize the tenant's right to also get the repairs done themselves and deduct it from their rent. However, if they do that, you can't go out there and get some quotes from your friends that are contractors that are some inflated quotes and then try to stick it to your landlord. The tenant has the obligation to try to save the landlord money. So if they try to do that, the landlord can say, no, screw you. I'm taking you to court to evict you then. And then you need to justify that you went and got 3 reasonable quotes to try to get the cheapest one to save the landlord money on those repairs, not going out there and getting some overpriced inflated ones. Okay. Let me know when you got that. I'm going to change the slide.
Done.
Everybody good?
I'm good.
Yeah, good.
So the state inspection, that green card, we call it the green card inspection. That's not the official name. That's the industry lingo's name for it. And that's required for buildings with 3 or more rental units. So if it's 3-family house, there's no 3 rental units if the landlord's living in one of them. There's only 2. So that building would not require a state green card inspection, just a local city inspection. But if the landlord's not living in it and it's a 3-family house, that requires the state inspection by the state inspectors from the DCA. Anything with 3 or more rental units available not counting the unit that the landlord lives in, requires a state inspection. So the DCA, the Department of Community Affairs, would be the ones that perform that inspection on behalf of the state. It's done at least once every 5 years. And so when you're selling a property that's 3 or more units, make sure that the green card's up to date, that inspection, because any potential buyer is going to want to make sure it is as well. And hotels and motels must be inspected at least once every 3 years, and those could be spot inspections without any prior notice. Landlords must maintain temperatures when heat is included in the rent, even if the tenant is not paying the rent. Otherwise, you're kind of evicting the tenant by, it's just like locking the door on them, trying to freeze them out, you know? So when heat is included in the rent, even if they're not paying the rent, landlord still needs to maintain the temperature to at least between October 1st and May 1st. It must be heated at least 68 degrees between 6 a.m. and 11 p.m. and at least 65 degrees at night. Now, some people may say, well, that's freezing. No, it's not. 32 degrees is freezing. So you cannot turn off the water, heat, gas, or any services that may be included in the rent, even if the tenant's not paying the rent. Move forward to try to evict them, limit your losses. Okay, typical leases restrict the tenant from subletting. We actually have it written in the lease that they're not allowed to. You can't sublet without the landlord's implicit permission. So, assignment transfers the lease obligations to another. However, the original person named in the contract, the lease contract, is never relieved of the original contractual obligations if the landlord were to allow you to sublet. But novation would relieve the tenant of any further obligations if the landlord were to permit it. Remember, novation is the substitution of one contract with a new agreement, or novation of the parties, replacing a person named in the lease with another, so that the original person has no further legal obligation or liability. That's a little bit different than assignment. You novate. And attorneys would handle that. Subleasing is a transfer of a lease if the landlord permits it, but the original tenant, once again, is still responsible if the new tenant does not abide to the lease terms. They're not making rent payments, for example, or violating some other term of the lease. Destruction of the premises would hold the tenant responsible for that. So let's put a highlighted box around this. This is how much notice needs to be given to terminate the lease at the end of the lease term. You know, the estate for years, no notice is needed because it has an expiration date in it. Remember, anybody who terminates a lease early, well, they're the breach of contract. What's that?
So Victor, I have one quick question.
Yeah.
As a rule, that even tenant is not paying you rent, the owner should maintain the temperature, do not disconnect the
If it's
electric or water.
if it's included in the monthly payment, yeah.
So now, question is that if tenant is not paying, and owner says, I also don't have money to pay. So then is PSNEG or the water sewer, because water sewer is by the government and electric and gas is by the PSNEG or any company. So how long they're gonna continue their electric or water?
Well, if you don't pay bills, when do they cut it off? I don't know. It depends on the utility company.
So what landlord gonna do? And if the utility company is
You
disconnected,
can't pay your bills. I mean, you can't pay your bills, you know, yeah, services are gonna get turned off.
Yeah.
It still doesn't change the law that requires the landlord to provide. If they included utilities in the rent, they have to maintain those utilities. You know, it's not enough. You can't just say, well, I can't afford to make the payments. Okay,
So landlord cannot say I cannot afford to pay.
yeah, that's not an excuse. Get rid of the tenant, evict them. Get a tenant in there paying the rent. But yeah, just saying you can't pay the rent. In most cases, that'll be doubtful, but either way, it doesn't matter. It's not an excuse. The law requires that if, you know, you're gonna keep the you know, temperature, if heat is included in the rent, you gotta keep up on the heat. Even if the tenant's not paying their rent.
Okay.
Mm. All right, hold on one second. I'm trying to find this. Let's see what happened. Wait, that was before this assignment and supplements. Okay. Okay, so the truth in renting booklet that's provided by the, you could get that from the DCA. Landlords are required to give it to tenants in buildings that require the state green card inspection. And which buildings are those? Those that have 3 or more rental units, not counting the one the landlord lives in. All right. It does not apply to commercial real estate. And you can get it from the DCA website. You could get that booklet. You could go to their website. And you can get it in English or Spanish, and here's a direct copy of the one, direct link to the one in English. You could go to the website and get the other one. Truth in renting and disclosure. Right, copy this, give that to you. Yep. So I gave you the link there to the DCA website where you can get all that real-time updated book, Truth in Renting booklet, or you could download the PDF one. Yeah. And a lot of information for landlords and tenants from that DCA page that I sent you there. Okay, so truth in renting, flood risk notification to tenants. Beginning March 20th, 2024, every landlord must provide the notice to prospective renters, including whether the rental property is located in a FEMA special flood hazard area or moderate flood hazard area, and acknowledge that the rental premises or any portion of the rental premises, such as tenant parking spaces, have ever been subjected to flooding before in the past. Landlords may also print a copy of the Truth in Renting booklet and flood risk notice forms from the DCA website as well. So here, I already gave you those other things. The DCA website and the Truth in Renting booklet. Here is the link for the flood risk notification. Same thing that this is. Let's see. Yeah. So the flood risk notification just tells the landlord or the tenant, you know, if the property was ever subject to flooding before in the past, and if it is in a 500-year or 100-year flood zone. The 100-year flood zone would require you to carry flood insurance. 500-year flood zone property is likely to flood at least once every 500 years. And then they got all their climate change nonsense in here, notifying you that they could tell the future and that the sea levels are going to be rising. Okay, that needs to be given to the tenants now as well. I think that's the same link as this. Yes, it is. Okay, so the Truth in Renting disclosure. Here, write this on the top of the page here where you see this. The Truth in Renting booklet must be given to tenants in buildings requiring the state green card inspection with 3 rental units, 3 or more rental units, not counting the unit the landlord lives in. So I highlighted Truth in Renting and wrote the act requires residential landlords of dwellings with, and I crossed out whatever was there and I wrote 3 units or more than 3 units if the landlord occupies one of the units to distribute the Truth in Renting statement to each of their tenants, and they need to post it publicly, like in the hallway. And violators are liable for a penalty of up to $100 per violation, it says. Just wait on y'all to tell me when.
Good.
Anybody still writing or?
Nope, we don't.
Yeah, done.
So the disclosure of the owners and managers to the tenants and to the municipality for emergency purposes is a requirement. It must be on file with the local government and state agencies when they register the property for rental purposes, like in case there's a fire or some other emergency or damage there. All right, the The landlord also has to notify the tenant if federal crime insurance is available at a subsidized price. I mean, not like renter's insurance costs that much, but apparently we also subsidize federal crime insurance in high-risk areas. So from the Department of Housing and Urban Affairs, you could get that federal subsidized crime insurance. So let me adjust that a little bit. The Americans with Disabilities Act, the ADA, this is, if you recall, we went over this in chapter 4, pertaining to discrimination, when we were talking about discrimination, but you can't discriminate against people with disabilities. The Americans with Disabilities Act was created to prevent discrimination in the workplace against people with disabilities. So Title III of the ADA prohibits discrimination in commercial buildings, requiring them to be handicap accessible. It requires that commercial buildings be handicap accessible, and all new construction has to be handicap accessible because it's easier to make it handicap accessible from the beginning rather than trying to retrofit an existing building. So when it is an existing building, the ADA may require it to be modified to be handicap accessible. Now, to what extent? Well, they recommend reasonably achievable accommodations, which means at little cost without massive retrofitting or remodeling. And that can be kind of subjective too. So it's useful to consult ADA experts and architectural engineers, which that could be kind of costly in itself. So some examples of reasonably achievable accommodations are lowering wall-mounted payphones, if you could still find them, lowering water fountains or installing a cup dispenser can be a good workaround for that. Changing the direction which doors open, adding ramping, changing door handles to push bars for handicapped people, installing auditory signals and braille buttons in elevators, or making handicap parking spaces available for people with disabilities where appropriate. So let's do these highlights about the ADA.
I'm good.
I'm good as well.
Okay. And service animals. We learned all about that. You can't discriminate against somebody who's renting because they need a service animal, even if you have a no pets policy. because they're not pets. They're needed for disability. You could consider the service animal as part of that disability. So by you not allowing it, you're discriminating against those with disabilities, in a nutshell. So only two questions can be asked with people with disabilities. Is the animal required because of a disability? And what work or task has the animal been trained to perform? And if you're a landlord for residential property and you're going to rent to somebody and they say they have a service animal, you could require them to provide a letter from their doctor or mental health professional on their letterhead with all their contact information that prescribes it. And this way the landlord can call up that medical professional just to confirm the need, so that they can make sure it's legit.
So I have a question.
Yeah.
How about if the landlord lives there and they are, let's say, allergic to a dog, highly allergic?
Uh-huh.
Can that be a reason to not because they don't want to rent, but because they're allergic? Would that be?
Well, the dog's not going to be in your unit. Is that going to be affecting you? Is that a reasonable?
Meaning, like, if they go into the hallway, common areas are being crossed. So just to know, not.
This would be my advice. Contact an attorney that specializes in this.
Got it.
Because there are situations if it would provide a major, not a major inconvenience, but that inconvenience is the wrong word to use. But yes, there are situations where a service animal can be denied. However, I would always direct somebody to consult with an attorney, because now you're messing with people's possible discrimination.
Mhm.
So I would say seek legal advice. Don't get it from me. Okay.
Yeah.
So these are just some more examples of reasonable, achievable accommodations for those with disabilities. So rental referral agencies must check if units are still available. So if you're a rental referral agency goes to apartment complexes and they try to get renters for them in exchange for a referral fee. That's not what most agents do. Most agents deal directly with landlords who are the owners and have rentals. Apartment complexes usually have their own rental office, with an agent sitting there. But we could get into agreements. There are some agencies that specialize in this, like bestrentnj.com there. I'm not advertising them, it just pointing out one of the very, very few that I know that specialize in this stuff. They only deal with the renters in apartment complexes. As a matter of fact, they made their whole website around it. Just as an example, I'll take you there. So Best Rent NJ here, they have, look, a lot of these are new apartment, but some of them are older. These days it looks like they're building them new everywhere, right? So they have 85 different communities, the apartment complexes, that they have contracts with the owners, that they try to rent out their units. Like here's a 55 plus community. They try to rent out the unit. Let's see how much they're going for in the brand new construction for 55 plus. 1 and 2 bedroom apartments from $1,920. So I'm guessing 1920 would be for a 1 bedroom. It is. Wow. And 2 bedrooms all the way up to $2,900. I guess they have different floor plans and layouts. So if you were to actually click on any of these, you could actually see the floor plans to see they put together a website, a nice website with all the floor plans and layouts that people can choose from the different styles. And I guess they charge the rent accordingly, and they have different sizes. So they tell the owner, hey, listen, well, we'll market your property. We'll put up a page for your property on our busy high traffic website that we advertise. And then if we get you a renter, you'll pay us a referral fee. Okay, so they got a bunch of that's how their website works. You know, they put up all these nice pictures, they take professional photography, they put up floor plans, and then they advertise it on their website, and they try to get a renter. Wow. So if advertised, because the complex could have their own rental office trying to rent out units and renting them out, if you advertise, if you're a rental referral agency and you advertise the rentals, you have to check every day with the owner to see if they have one of those units still available or not. And if it's an in-house only listing that's not advertised, just shown to people who walk into the office, we need to check every 3 days to see if a unit is available. So if advertised every day, if it's just an in-house listing, we need to check every 3 days. You'll need to know that for exams. I think there's a question on that, as well as advance fees of more than $25 need to be put into escrow. So you guys got these highlights here that say the same pertaining to rental referral agencies.
Yeah, I got it.
Getting caught up on my notes now, too. All right. Control laws are set by each municipality, but not all municipalities have rent control. These laws are put into place to prevent abusive landlords from taking advantage of tenants. Controls raising rents, charging late fees, evicting tenants. All that can be covered under the rent control rules if a municipality has them. The rent control, it looks like it's a law to keep, abusive landlords in check. However, although rent control clearly benefits tenants, many argue that in the long run it could hurt them because the landlord's not allowed to raise the rents in line with the cost of living and maintaining them. So if that's the case, the landlords are limited in how much rent they could collect, and over the period of time, this could cause them to not be able to collect enough money to keep up with the maintenance and repairs of the building. And they could allow those buildings then to start falling apart and crumbling and actually having the adverse effect of becoming a slum. So that's why we say that, it can be a negative thing too. It could discourage investors from putting up rental housing and could cause hardships on landlords who cannot bring their rents up to fair market value, encouraging them to let the buildings deteriorate and eventually be abandoned. So rent control is good to a point. It's well-meaning, well-intentioned, but a lot of these well-meaning, well-intentioned laws that don't allow for gray areas and common sense, well, they could backfire on you. And rent control is one of those things. They're well-meaning, well-intentioned to protect the tenants, but it could backfire and cause a landlord not be able to collect enough money over the years as the buildings get older to be able to maintain those buildings, and then and make a living, because that's, it's not a charity. So the landlords may say, do I feed the kids, or do I dump all my money back into the building? And it may cause them to let the building fall into disrepair. So that's the risk right there. Where the heck is my nose? There we go. And condo eviction. Certain tenants cannot be evicted during condominium conversions. Those that are age 62 and older or have certain disabilities. They must have lived there at least 2 years before the conversion began, and their income is no more than 3 times their county's per capita, or in any case, no more than $50,000 a year. And if they meet all of those criteria, they could remain as tenants for the next 40 years. So you can't evict them until they're 102. And then by then, you're just a meanie. Evicting an old 102-year-old person. All right. So let's do those highlights on evictions of who cannot be evicted. I think we did this in another chapter too, but we got it here again. Let's just write next to condo conversions there. This is on page 245. 245 under the title of eviction. It's that second paragraph down there. That's where this is located. And just write condo conversion evictions on the side of that, and just put a highlighted box around it, or highlight that info that you needs to know.
Got it.
Okay.
So,
Same.
Victor, I'm a little bit confusing here.
Sure.
The word is saying here, the tenants so protected must have occupied the premises for at least 2 years before the conversion, and then have income no higher than 3 times sub capita or higher than more than $50,000. If they meet the qualifications, they are allowed to continue to be tenants for next 40 years.
Continue being renters, because they're converting these to condos, which would be, then they sell the units, and it would be and then they'd pay monthly HOA fees, but there would be no renters anymore. But if you have tenants that meet all these requirements, you can't require them to kick them out if they don't buy a unit, because you want to sell the units. You have to allow them to continue renting there for the next 40 years.
Okay, got it. Means that if I am 62-year-old and if my income is $50,000 and above, then the owner cannot evacuate me even if he's converting that apartment into the condo, correct?
If it's 50,000 or below.
Oh, 50,000 and below. Oh, I thought it's
Yeah.
above. It's a below.
It's no higher than 3 times their county's per capita income, or in any case, no higher than $50,000.
No higher than, okay. But everyone has more than 50, so.
Yeah. Okay, so now eviction, there's different types of eviction. Constructive eviction sounds like construction there, construction. This is an action taken by the tenants to legally terminate their lease early if the landlord fails to provide basic services or make essential repairs when there are uninhabitable conditions present. The tenant must notify the landlord that there is a problem, and if they don't fix it, vacate, move out, and then stop paying rent. The tenant would notify the landlord that they're terminating the lease early due to constructive eviction and they want all their security deposit back. They should seek legal advice for this. We shouldn't really give advice on this. This is legal advice, even though I have given advice on this before. But then I gave the person an attorney's number and I say, make sure you call them first because this is legal advice and I don't want you doing the thing wrong and me getting you jammed up because I'm telling you to do something wrong. I'm not an attorney. Just call the attorney and, he'll give you his 2 cents over the phone, what you could do there. So, and then the landlord must return all the security deposits as well. So this is called constructive eviction. Okay, so eviction. We're going to go over constructive eviction and actual eviction, 2 types of eviction. This is an action taken by the tenant when the landlord fails to make essential repairs because it is in uninhabitable condition. So I drew a little drawing here, giving you an example of the case that I had come across. The landlord was my client, and then I got a tenant she was a young single mom, newborn baby. This was a basement unit apartment that was actually grandfathered as a 2-family house. In actuality, it was a 1-family house that they put this outside door going to the basement, and then they got it grandfathered, and he's able to rent it out as a 2-family. Because you also have 2 ways in and out. You had this one, and then the stairwell that went upstairs. But that door was required to be opened in order to have this as a rental, which is kind of weird if you're got 2 different families and you got to have the door to the basement. They could go there anytime. So that was always locked. So that was always in violation too. But for inspections, it was unlocked. Now, what happened here was the girl called me after living there several months into it. After I got the tenant, we did the city inspections. Tenant got the keys, landlord got the money, and she moved in. A couple months later, she gives me a call. Vic, the landlord's really good at communication. However, he only likes to communicate by text message or email. He doesn't like to communicate by phone. But I'm having a problem because he's not replying to me anymore, and I got an issue. I was like, well, what's the issue? And she's like, well, I first noticed this when I was bathing my newborn baby in the little plastic tub inside the tub. And she said, every time they flush the toilet upstairs, it comes out in my tub. I would think that classifies as an uninhabitable condition. What about you? Somebody taking a leak or taking a poop and then it comes out in your tub every time they flush the toilet upstairs? That's disgusting.
Yeah.
You know, and especially you got a newborn baby, and that's when you first notice it, is when you got a newborn baby that you're washing in the tub, you know, but you put them in that little plastic tub, you know, inside of a sink or the tub, you know. So she had him, the baby inside the little plastic tub inside the tub, was washing the baby, and they flushed the toilet upstairs, and then it started filling the tub up with that nastiness. I would be fuming, you know, and so what happened here was that the sewer pipe collapsed on the guy's property, not in the street. So it's not this the utility company's problem, it's his. So he would have to pay to get that. Every time they flushed the toilet, it would go down through that sewer pipe, hit the blockage, and then back up to the lowest point, which is the tub in the basement. That's why it was doing that until it slowly drained out. But so he would have to pay $1,500 to $2,000 to get that segment of pipe replaced. And I guess he was just delaying putting that off. So she asked me what to do, you know, and I said, well, can you document that you've been in communication with the landlord, notifying him about this? She said, yeah, I got all the texts, I got all the emails. I was like, okay. Well, first thing you do, you go down to this was in Edison. I said, you go down to the health department, because they're the ones that manage the rentals in that town, and you file a complaint with the health department. And then you got anybody you could temporarily move in with, a friend or family member or something, while we look for another place for you? And she's like, yeah, I got a friend I could go in with. I was like, okay. So then what we'll do is you move all your stuff out, and then stop paying rent only after you moved your stuff out, and then notify the landlord you're terminating the lease early due to constructive eviction. And then there's not a damn thing he could do about it at that point. But make sure you talk to an attorney first. And I gave her an attorney's number who would to confirm whether I gave the right advice or not. It was an attorney I knew, and you know, he wasn't going to charge her for that over the phone consultation there. And so he confirmed I gave her the right advice. And you know, the thing is, when she went down there to City Hall and to the health department, the two girls over there in City Hall, they were like, guess who it is? You know, like talking to each other. And the other girl was like, no. And they're like, yep, it's Chester. And it's like, they knew, they're like, oh, this guy's horrible. They said he owns a bunch of rental properties all over. He slaps paint on it or whatever to make it look nice when tenants move in. But then when it needs work, he refuses to do any work until we go down there and force him to do it and start issuing him fines, you know. So we'll take care of this. And yeah, but that's all fine and dandy, but she didn't want to deal with it anymore. So we filed the complaint, or she filed the complaint, but then we got her out of there, and she did that constructive eviction. So this is an action taken by who? Constructive eviction, an action taken by the tenant to terminate a lease early due to uninhabitable conditions when the landlord fails to make these essential repairs or refuses to. So that could be helpful for the tenant, but it could also be an intended abuse by the landlords in some situations where a building may need some repairs pretty bad, and they want to get a tenant out so that they could do the repairs and improvements, and then get a higher rent paying tenant in there. That would be illegal for a landlord to do. It could be constructive eviction can be used by a landlord for that purpose as well. But it's usually an action taken by the tenant to terminate the lease early. You know, but whether it's the landlord that's not doing the repairs on purpose to try to get them to kick themselves out and have less of a headache, or if it's whatever the reason is that they're not doing it. You know, this guy is just cheap. Yeah, and then he called me up on the phone and started yelling at me. You know, he didn't know, by the way, that I was talking to her. You know, and he was yelling at me about I paid you a commission to get a tenant in there for a full year, and she already moved out. She broke the lease and already moved out. And I was like, well, actually, she called me and I know what was going on. I was like, it's pretty messed up what you did to her. I was like, why didn't you do the repairs? I was like, that's disgusting. Would you want to live like that? No, it's like, well, I paid you a commission, for a tenant that was going to be there for 12 months. And, she moved out early. So, I want my commission money back, or you need to get me another tenant, and not charge me a commission. I said, I'm not doing that. I said, I earned my fee when I produced a ready, willing, and able tenant. We got the city inspections, the lease date came about. You got the money, she got the key. I earned my commission, I wipe my hands of it. It's now a landlord tenant issue. Because you can't keep your tenants because you're acting like a slumlord. That's not my problem. I was like, I'm not going to continue getting you good tenants in there if you're going to be abusing them like this, you know. And he's all like threatening to sue me and everything. Oh, by the way, the guy was an attorney, so he's trying to throw his weight around to sue me. And I was like, dude, you can threaten to sue me all you want. I was like, you know just as well as I do that you ain't gonna win squat. It's frivolous because it's a landlord tenant issue and has nothing to do with me. I did what was required in order to earn my commission, and now it's on you. Now you're just being cheap. You don't want to do the repair. You're forcing your tenant to live in a disgusting condition. I was like, don't call me if that's the way it's, if you're going to be a slumlord like that. And he started like yelling and cursing, and he's going to sue me. And I just hung up on him. Never heard from him again. But sometimes you got to deal with people like that. Okay, so you need to know what constructive eviction is. It will be on exams, which is different from actual eviction. So a suit for possession or actual eviction, this is an action taken by the landlord, the traditional type of eviction that we're used to, that we know about. So in a suit for possession or actual eviction, this is the action taken by the landlord. The eviction is the process of the court revoking the tenant's rights if the tenant breaches the terms of the lease. The landlord files for what's known as a summary or dispossess proceeding to try to dispossess the tenant from the property, get that possession back. A landlord must provide a notice to quit before they can file for eviction if they're violating the terms of the lease. The only exception that does not require a landlord to serve the tenant with what's known as proper notice or notice to quit is for non-payment of rent. If the tenant is not paying their rent, a landlord can start the eviction process at any time without serving papers to the tenant to quit the lease breaking activity that they're doing. So how much notice is needed to provide a tenant before filing for eviction for various lease breaking activities? Well, there's a little guide here in the book. I call it the Landlord's Guide for Giving Tenant Notice to Quit before filing for eviction. Yeah, I know it's kind of wordy, but it explains exactly what it does. So let's first do the highlights here now in the book. For constructive eviction, make sure you write that little note there that I wrote up top here, and then highlight suit for possession or actual eviction down below it.
I have a question.
Sure.
Once the tenant does that action to terminate the lease, can they go after the landlord for their money owed to them or whatever?
Well, their security deposit, the landlord must give them the security deposit back.
Okay, just whatever.
So if the landlord doesn't, yes, they can go after them because they're supposed to give it back to them. Okay, you guys got these notes or highlights, or are you guys still highlighting and writing notes?
Yeah, got it.
All right. So here are those causes for eviction. And once again, remember, non-payment of rent, no notice to quit is required to be given to the tenant for non-payment of rent. Any other provisions, any other reasons would have to have been written in the lease itself. Landlord cannot take try to evict a tenant for something that they never gave them notice about. It has to have been written in the lease that there are some restrictions or lease violating things that they're doing, and had to have been in the lease in order for them to know what the rules are, right? So here are those. This is what I call the landlord's guide for giving tenant notice to quit before they can file for eviction. At least that's what I wrote above it here on the page. I know on in this version of the book, it's not on one page. It's actually split on two, on page 245 and 246. It's towards the bottom of the page there where it says causes for eviction. Write that next to the title so that you know what it is. And then also highlight non-payment of rent. Notice to quit need not be given before the suit is filed. That's the only reason. And once again, here's another reference to TV shows or movies, right? This was a TV show that used to be on a channel called Spike TV. It was like the Man's Man channel. And it was called, there was a show here called The World's Worst Tenants. And it was a reenactment of these a landlord, tenant, people who have a job to communicate, do the communication between the landlord and tenant. Follow up on complaints from tenants, serve papers to tenants by the landlords, and they come across some pretty sketchy situations in this show. It was quite entertaining, to say the least. So I do have that link in the class links Word document. You guys can check out, but I'll also give it to you right now. I could share that with you. It's pretty entertaining program. You guys can check it out on online here still, or even on Tubi TV. I think they got it as well. You could watch those. There you go. World's Worst Tenants.
I'm good.
Okay.
Good as well.
So
Yeah.
the
Yeah.
only reason that a landlord can take action to evict a tenant without serving them with a proper notice first is what? Non-payment of rent. For other things, this is a guide showing how much notice or how many times notice needs to be served to a tenant. All right, page 246, payment and what's included. Let's write that next to the title there where it says types of leases, right? Payment and what's included. And then down here next to net lease, I want you to write three N's, three capital N's over there like that. And after it says pays rent plus all most property charges, right, except mortgage financing. Let me know when you got it.
Done.
That's not the pick of this slide, even though the stuff's in the book. Some of it isn't, like CAM, what CAM is. So we're not talking about types of leasehold estates here. We're talking about payment and what's included when we talk about the types of lease. You have a gross lease, which is common in residential properties. It could be used in commercial, but it's more common in residential, where the tenant pays a fixed rent and the landlord's responsible for all the property expenses for taxes, insurance, mortgage payments, any repairs connected to the property. In a net lease, the tenant pays their rent and some of the property charges, whatever was agreed to in the lease. Now, there's a variant of that called the triple net, or NNN, where the tenant pays rent and all other property expenses like CAM charges and repairs and the like connected with the property, except for debt services, the mortgage loan. And then CAM is common area maintenance charge. Each tenant must pay their own share of these fees proportionate to the percentage of the total space of the area that they're renting. Here, let's start by doing these notes. Let me know when you got that.
Done.
And then these notes. So a percentage lease. Did I have that written on the previous slide? No, we had gross lease, net lease, and CAM. We did this. All right, percentage lease, I guess, is coming up on the thing here. I could change the order of the slides. Yeah, I'm gonna do that. And that's good. Just leave it like it is. Okay, so percentage lease provides that rent be based on a percentage of the gross income that the tenant's receiving. So the tenant pays a small fixed rent and a percentage of their gross income. They have to share that with the landlord. Or in this case, it's a percentage of their gross income above a certain dollar amount monthly. In this case, it would be $30,000. So if a tenant, you guys ever go to Woodbridge Mall or Menlo Mall or any of the malls, and you see that there was a store that's doing killer business. They're always busy, and they're there one day and then they're gone. You guys ever wonder why they're gone? They were so busy. They were always packed, and now they're gone. You guys ever wonder about that?
Yeah.
The stores, you mean, in the mall?
Yeah.
Yeah, a bunch of times when I go there, I'm like, wasn't there was a store here like a couple months ago, and now it's
But if it
gone?
was a busy store, it seemed like they did really good business, and then they're gone now. You ever wonder why? There's stores that they just fail because they're not making enough money to pay the rent and everything. But what about a store that seems like it's very busy? Well, you know what? You could have had a store there that was very busy selling their widgets. That's whatever their product was. And we'll call it a widget. And they were busy selling a lot of widgets. However, the income that they were producing was not enough to satisfy the landlord's voracious appetite of their lease requirement. So even though they charge a small fixed monthly rent, they required a percentage of the income. And maybe the tenant was not producing a large enough income to meet the requirements that were written in the lease. And that's why they're probably gone.
I used to have a cousin who owned Junior's Kitchen at Menlo Park Mall like 3 years ago, and then he got out of there for the same reason.
Yeah. Because although you may be busy and doing really good work, the landlord, they're basically not making enough money to pay the rent, because the income in this case is considered as part of the rent. And the landlord specified, hey, even though you got a low fixed monthly rental payment of $1,200, you got to pay 5% of all your gross sales in excess of $30,000. What if you're not making $30,000? Or it could be you've got to pay 5% of the gross sales in excess of the dollar amount, and there has to be a certain minimum. Could be written into the agreement. And if they're not reaching that amount, well, then the landlord can be like, well, then we terminating the lease, you got to go. Those percentage leases are kind of similar in those programs that you see on TV, like Alaskan Gold Rush and things of those nature. But those are like mineral leases, but they share a percentage of the income that they make with the landlords in those agreements too. Now, here's how you calculate the rent with a triple net lease. If the rent is $20 per square foot, all right, and the CAM charge, let's just say they give you an estimated CAM charge of $5 per square foot. Do not add both of these up to $25, because the CAM charges, the tenant's going to be responsible for paying the actual charges. They could be higher, they could be lower. So that's just an estimate or guesstimate based on the past, okay? So you should calculate these separately if you do get a CAM charge estimate there. But you could ask them, what is the approximate CAM charge? So this is the way they give you a ballpark figure. So if they tell you rent is $20 per square foot, this is how you do it. If you're renting 2,000 square foot of space, you do 2,000 square feet times the $20 per square foot. That's $40,000. That's not per month, that's annually. So you divide it by 12, and your monthly rent is $3,333.33. Now, tenants are also responsible for paying landscaping fees and maybe for a security system on the building, the sprinkler system, the owner's insurance on the building, in addition to your own business insurance, any other kinds of maintenance or repairs the landlord chooses to do. They pass those expenses on to the tenants. The taxes, in commercial real estate, the tenant even pays their portion of the taxes, the property taxes on the property. For instance, I'm doing that. I'm renting about 2,000 square foot of space for the school, and I'm renting about 5% of the building with 2,000 square feet. So I'm responsible for 5% of the landscaping fee, 5% of the property taxes, 5% of the sprinkler system inspections and fees, 5% of all charges, all those common area maintenance charges. So if it's estimated at $5 a square foot, you take we're renting 2,000 square feet times $5, $10,000 divided by 12. That's an additional $833.33 a month. Now you add them both up, and you can see what the total rent is: $4,166.66. Now, why did I add them up separately? Well, because you need to know what your actual rent is, and the CAM charges can fluctuate. And landlords should also provide the tenant with the actual receipts, the bills that they paid that you're responsible for reimbursing them for. And that's pretty common in commercial real estate. That's the way it works. So I guess it pays to be a commercial landlord, right? Yeah, your tenant pays for all property expenses except for debt services, the mortgage. They even pay your taxes. They pay to keep up your building or any repairs or maintenance you're doing on the building. You pass those charges on to a tenant in commercial real estate with these triple net leases. Plus, you get the added bonus that your tenants refer to you as Lord. It's a joke. All right. So that's how you calculate the rent on a triple net lease. Okay. So percentage lease is common in large shopping centers. Tenant could pay a small fixed rent plus a percentage of the gross income. A percentage of their gross income in total, or perhaps above a certain amount figure, with a certain minimum even attached to it. It depends on how the agreement was written up and agreed upon between you and your landlord. So landlords could add a provision: the tenant must gross a certain minimum in sales as well. Rent may vary according to the nature of the business and the rental agreement. So this is common in large shopping centers. A type of rental agreement where the tenant pays their rent plus a percentage of their income, plus a portion of their income. What is that called? A percentage lease. Okay. Now, where it says other lease types here, they're not talking about other leases. They're talking about provisions that are added into longer-term leases. We call those variable leases, where you know what the rent and the CAM fee is for 1 year, and then the next year the rent goes up to a certain predefined amount, either by a certain dollar figure or percentage. And then by the next year, it goes up another percentage. And then the next year, another percentage. Okay. These are known as variable leases, or they could be tied to a cost of living index, a cozy index, we call that. So they can write in the lease that the rent is going to be this much. And then next year, the rent will go up by whatever amount is published in the New York Times business section in the second Sunday of the month of the cozy index. It could be written something along those lines. Now, a ground lease is also known as a triple net. It's also a triple net lease. What is a triple net lease? It's one where the tenant pays their rent plus CAM charges, all property expenses except for debt services. So in a ground lease, the tenant rents land, and then they construct a building on it. They're usually long-term leases. 50 to 1,000 years is not uncommon. Yeah, I know. Who's going to live 1,000 years? Who would enter into a 1,000-year lease? Well, it could be some kind of a fund or a business type structure where it'll be a long-term lease. Some famous ground leases are the Empire State Building, the MetLife Building, the former Pan Am Building, the Chrysler Building, the World Trade Center buildings in New York City. All the land was owned by the Port Authority of New York. They do long-term leases for the ground, and investor constructs a building on those grounds. Could you imagine that, constructing a large building like the Empire State Building and not owning the land that it's sitting on? So do not confuse a ground lease with a land contract. What's a land contract? It's a type of seller financing where the owner doesn't give you the deed until you paid off the full amount owed. So do not confuse a land contract, which is a type of seller financing, with a ground lease where somebody rents the land and then constructs a building on it. And then they're responsible for all the property expenses. The taxes would go up because now you've got a constructed building on it. You're responsible for all the maintenance on that building that you constructed as well. So that's why ground leases are also triple net leases. And then we have a mineral lease or oil or gas leases. Those are mineral leases and oil gas leases. The landlord rents the land to a tenant who then tries to extract the minerals from the ground, whether it's an oil or it's a gas or it's a liquid, like oil. The landlord collects the rent plus a share of the percentage of the profits. And just like with a percentage lease, they could put minimums on there that they need to earn at least a certain percentage. So, like, you guys ever watch TV programs like Alaska Gold Rush? Anybody ever see that on TV, even in passing? It's been on TV for a bunch of years already.
I've seen a commercial for it, but not.
Yeah, it's basically these guys that they got gold fever. They're out there trying to in Alaska trying to get the gold out of the ground, but they got to know how to track down the gold, where the gold is. They got to follow the glacier patterns of how the glacier cut away at the land. It usually pushed a lot of the minerals and created these vines of where the gold can be located. It's usually by black dirt. Once you hit the black dirt, I watched it a few times. But it's interesting. But the thing is, most of these guys do not own the land that they're digging on. So they're basically got heavy equipment they bring in. They dig and move tons and tons of dirt. They put it on a conveyor. They try to sort the dirt and separate it from the rocks. They run water over it. It's kind of like a major panning session, and see how much gold that their sluice box can collect. And then sometimes they get really nervous because they're paying a rent to dig on the land, but they also have to split a percentage of it with their landlord. And it's part of their lease agreement that they need to come up with a certain amount, a minimum, you know. And if they don't, their lease can be terminated. And they could have a lot of money and a lot of hard labor in that land already now. So this is why they get like really nervous when they're like, oh, the landlord's coming to visit next week. So now they stop all operations and they start just running the dirt they already dug through the machinery and stuff to try to pan for the gold and see how much they got so far to see if they're on target. You know, I guess it can be kind of nerve wracking, but that's what they do. It works kind of like a percentage lease. They're paying a fixed rent plus a percent of whatever their gross income is. All right, then so here now are those notes that we write in the book. It's the same notes pretty much where I give all these explanations on these slides. Here, we could just write this. Next to variable leases, just write provisions added to long-term leases and write all these notes and do the highlights. And let me know when you got it.
Done.
Okay, thank you.
Got it.
Check this out. The Empire State Building, that world icon. Imagine constructing a building like this and not even owning the land that it sits on. You better get a long enough lease that the juice is worth the squeeze, right? So, what are the primary functions of a property manager? Well, it's to maintain or increase the value of the property while generating income as an agent for the owner. That's pretty much what it is in a nutshell. And that's what you should know. Usually if I ask people what the primary function of a property manager is, they start talking about all the micromanagement tasks of getting tenants to fill the spaces, evicting tenants that aren't paying rent, keeping the property up to snow removal and the garbage and all that stuff. Like you're fixing and doing minor repairs, and so I get a lot of this micromanagement stuff. But really, if you were to take the 1,000-foot view from above, what is the primary stepping back from the details, stepping back a bit, taking that 1,000-mile view? The primary function of a property manager is to maintain or increase the value of the property. And sure, you do that by, doing all those functions that we were talking about. But an overall answer for this statement is you're maintaining or increasing the value of the property while generating income as an agent for the owner. That's basically what you're doing. And you need to know that definition. What is the primary function of a property manager? Sure, they secure suitable tenants, collect rents, care for the premises, budget and control expenses, hire and supervise employees versus independent contractors to maybe do work on the property and work for the owner of the property, not the property management company. You know, to find like snow plow removal companies, those may be independent contractors for the plowing. But you know, maybe hiring a maintenance guy that will be an employee for the property property owner to do certain repairs instead of them doing the repairs at the property management company level. Depends on what was agreed to in the property management agreement, which acts as your limited power of attorney, which gives the property manager the rights to do certain things on behalf of the property owner to legally, possibly legally bind them to contracts like employment agreements and such. So let's highlight this and I want you to put that little arrow in there and make increases where it says a property manager is someone who preserves the value of an investment property while generating income as the agent for the owner. I want you to write after preserves, put that arrow there and write or increases the value of an investment property.
Done.
Okay. Everybody else good too?
Yeah, me as well.
Yeah.
So the property management agreement is a written agreement that creates the agency relationship between the owner and the property manager. It acts as their limited power of attorney, which defines the scope of the authority that the owner is giving to the property manager. And that may also include the ability to legally bind their clients to contracts by signing leases with tenants because the landlord maybe doesn't want to be involved in that. Or while most real estate agents function as special agents, the property managers generally work as general agents. So a general agent, when speaking in general, we always do this with our hands. It's a wider scope. In general, when talking in general, it's a wider scope of authority. So special agents can not legally bind their clients to contracts, if you recall from chapter 3, and general agents can. And who generally works as a general agent? Property managers that were given the authority to legally bind their clients to a contract, possibly. And where would that be written? It would be written in the property management agreement. That would be their limited power of attorney that defines the scope of how the property manager can legally bind their clients to contracts. Now, just like special agents, general agents, they have the fiduciary duties. The property managers have the fiduciary duties of an agent: cold, care, obedience, accounting, loyalty, which includes confidentiality, and disclosure, which includes notice. So highlight this on page 248. A property manager is usually considered a general agent, whereas most real estate brokers function as special agents. You're very special. That just means you cannot legally bind your clients to a contract working in one capacity only. So property management, some of the property management concerns that a property manager may have are budgeting expenses, operating expenses, capital expenditures, renting out the property and setting those rental rates, selecting tenants and collecting the rents from them, and then rendering accounting to the property owner. So they're maintaining and improving the property, maybe hiring employees or contracting for services. Insurance, evaluating they have proper coverage on the property, not too much of this, not enough of that, you know. They want to make sure they have proper coverages on the property as well. So if you guys are interested in the property management field, getting involved in that, here's a course you could take. It's called the CPM, the Certified Property Manager. Okay, that's only one. There's other courses out there for this kind of stuff too. It is a designation class. From what I hear, it's a decent class to get involved in property management, if that's the area of real estate that you wish to go into. And if you wish to get involved in managing condominium complexes, you could take courses from CAI, the Community Association Institute. This is a resource for those individuals that manage condominium complexes and cooperatives and such. It teaches you the ins and outs of that stuff. All right. So CPM, Certified Property Manager. And then you could also, if you're interested in running condo complexes, well, you could take some classes from them as well. Okay. So once again, here's a list of a bunch of designation classes and courses that you could take. And information for landlords and whatnot. Here, I'll share that with you guys in the chat window as well. Boom, 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 boom. So let's just highlight in the book, CPM, Certified Property Manager. Okay, this has been around, let's see. The Institute of Real Estate Management created the CPM designation course. The Institute of Real Estate Management, IREM, was founded in 1933 and is part of the National Association of Realtors. Members can earn the designation CPM. The Building Owners and Managers Association, BOMA International, is a federation of local association of owners. And managers primarily of office buildings. Participation in groups like these allows property managers to gain valuable professional knowledge and to discuss their problems with other managers facing similar issues. A growing field of management of cooperatives and condominiums. The managers hired homeowners organization. Look at all these high rises, all these buildings they're building all over the place. Some of them are rentals, some of them are condos. Either way, they both need to be managed in some way. So if property management is a thing that interests you, well, that's another area that you could of the field that you could get into. You know, I never spoke to any of you guys asking you guys why you're getting involved in real estate. What do you want to do in real estate? You want to sell homes? You want to rent them? You want to deal with new construction or resale properties? Do you want to deal with investors? Are you dealing with fix and flippers? Are you dealing with, do you want to get involved in property management or residential versus commercial real estate? Do you want to deal with low-income housing or affordable housing? That's always a big thing, especially right now, or they're trying to get these things going. But you know, don't look down on that either. You know, I know that most agents, they get involved, they want to they get their license, they want to think about selling those expensive, rich mansions, the expensive homes, the beautiful ones. But listen, there's a lot of money to be had in low-income housing as well, and affordable housing. I know one girl came to me to take a broker's course with me once before, and in the class, she asked a question. This was when we were still meeting in person. She asked a question. She was like, what does the MLS look like? And everybody shot a look at her like, how the hell did you get this far that you're trying to get your broker's license now and you never even seen the MLS? And, I told people, I was like, you know what? They're chuckling amongst themselves and talking about her now. And I was like, guys, you're pretty stuck up. I'm like, well, why are you guys looking down on her because she's never seen the MLS? That's not the field of real estate that she entered into. She's dealing directly with the owners of a building that are constructing affordable housing and low-income housing. Now, you may be snickering over that, but let me ask you guys, what's the most money that you ever made to date in a single year? And he had this one guy in class in his suit, and he always acted like his crap didn't stink, and he was like, I think it was around $150,000, and he was all, ho, ho, ho. And I knew what she made because I had a previous conversation with her about it on average. So I asked her, I was like, what do you average every year? And she's like, well, it's a little bit different, the way that it works, but it's approximately the same. It depends on the projects that are going on, but I average about 300,000. Double what they were making in low income and affordable housing. There's a lot of money to be had there. People throw a lot of money at that stuff. Government, politicians, investors, they have to. All right, so this concludes chapter 12. Let's do the key terms to review. Before we do the key terms to review, there's a section on page 250. There's a paragraph there on the second paragraph on page 250. It's a pretty interesting paragraph. We skipped over a lot of stuff here because it's just like skims over things and doesn't really give you a lot of useful information. But setting rental rates, which is the bottom page 249, carrying on to page 250. And it's interesting. It says, well, let's first read it here. If establishing rental rates for a property is a basic concern that must be that in the long term, the income from the rentable space covers the fixed charges and operating expenses and also provide a fair return on the investment. Consideration must also be given to the prevailing rates in comparable buildings and the current level of vacancy in the property to be rented. Supply and demand also needs to be taken into consideration there. So following a detailed survey of the competitive space available in the neighborhood, prices should be noted and adjusted for differences between neighboring properties. And the property being managed, annual rent adjustments are usually warranted. Rental rates are stated in a monthly amounts, but office and commercial space are usually stated as either an annual or monthly rate per square foot of space being rented. So if a high level of vacancy exists, an immediate effort should be made to determine why. Why do we have so many vacancies? A high level of vacancy does not necessarily indicate that rents are too high. The trouble may be inept management or defects in the property. The manager should attempt to identify and correct the problem first rather than immediately lowering rents. Conversely, a high percentage of occupancy may appear to indicate an effective rental program, but it could also mean that the rental rates are too low. With an apartment house or office building, anytime the occupancy level exceeds 95%, serious consideration should be given to raising the rents. Because you're renting them all out too quick. Raise the rents. And now you see in some strip malls and such, a unit that may be vacant for years on end. Well, they're just holding out for the right tenant to sign a long-term lease at a much higher rent and larger security deposits and all that. All right, guys, let's do the key terms to review. There are 2 of them for this chapter, and then we'll break for lunch. Okay. So landlord's responsibility for decent conditions. What do we call that?
Landlord.
Landlord's responsibility for decent conditions that they need to provide for you. If you're renting a property,
Assignment?
if you're renting a property, it's assumed that there's no unsafe conditions, that it is habitable condition. So 9 is A, implied warranty of habitability. That's the landlord's responsibility for providing.
Okay, plan to habitability. Okay. Yeah.
Make sure that they're habitable, So 9 is A. A transfer of property by lease is known as
Demise.
demise, or is B. A situation when a tenant remains after their lease period has expired.
What is called?
Estate for years?
Now, what do you call it when the tenant did not move out after their lease expired?
Holdover tenant?
They're a holdover tenant. They've held over after their lease term had expired. 8 is C. A contract between a landlord and tenant transferring the right to use real property for a specific period of time in exchange for rent. What do we call that?
Lease?
It's a lease. 10 is D. A lease for a definite period of time. It has a start date, end date.
That's
What?
ground lease.
Oh, no. A lease for a definite period of time has a start date and an end date. You know when the lease term is going to begin, and you know when it's going to end. It's in a state for years.
Oh, I said that.
Oh, you did? Okay, I didn't hear you then. An estate for years, it's for a fixed term, has a start date, has an end date. 5 is E. Suit for possession, legal removal of the tenant. What is that known?
Okay. Actual eviction?
1 is F, actual eviction.
Actually,
Rental of land on which tenant erects their own building.
That's a ground lease?
ground lease.
It's a ground lease. 7 is G. The tenant. What do we call the tenant?
Lessee.
A lessee. 11 is H. A lease under which the landlord pays taxes, insurance, and other expenses. A lease under which
Gross
the
lease.
landlord pays these things. Yes. 6 is I, a gross lease. A transfer of primary responsibility for a lease to another party.
Assignment?
2 is J, assignment. And a tenant is forced to move because rental unit becomes uninhabitable.
Constructive.
Excellent.
Constructive eviction. 3 is K. All right. Let's go do the second key terms to review. But before we get started, at the end of the line for B in key terms to review, at the end of the line for B, where it says tenants remain after the lease term without landlord's consent, right, and not paying rent. Or just right, not paying rent.
Yep.
And then go down to letter D. And right after that, automatically renew. Automatically renew.
Yeah.
All right. So a lease under which a tenant pays expenses like property taxes, insurance, and so forth. What type of lease is that? Where the tenant pays those bills.
Net.
It's a net lease. 3 is A, correct. Tenants remain after the lease term without the landlord's consent, and they're not paying rent.
That is tenancy at suffering.
Yeah, 9 is B, tenancy at sufferance. A lease in which a landlord shares in the gross receipts of the tenant's business.
A percentage lease.
The percentage lease, 4C. A lease with regular payments and no stated ending date. It automatically renews for the
Periodic lead.
similar succeeding periods. What?
Periodic lead. Sorry, periodic estate.
Yes, periodic estate. 5 is D. A person who looks after another's rental real estate. What do we call that person?
Management.
Property manager.
Property manager. Yeah, property manager.
6 is E. Tenancy that may be terminated when the landlord or tenant wishes.
Yeah, well.
Yeah, tenancy at
Tenancy
will.
at will.
10 is F. Landlord's court action to evict the tenant.
No.
Yes.
Suit for possession.
Oh, yeah.
8 is G. 8 is G. Suit for possession. A transfer of only a portion of the lease.
Sublease?
Sublease. 7 is H. Property manager's employment agreement.
Management agreement.
2 is I. The state requirement that tenants be notified of their rights.
Truth in renting.
11 is J, truth in renting. And another word for landlord.
Lessor.
The lessor. 1 is K. They are the lessor. Okay. And that concludes chapter 12.